case that has created a huge debate in India with regard to reproductive rights and the term at which an abortion can be conducted. The Supreme Court, in its order today, has denied permission to a 27-year-old woman who wanted to terminate her pregnancy after 24 weeks. The Chief Justice's bench has said that because there is no fetal abnormality and there is no threat, no immediate threat to the life or health of the woman in question, the provisions of the Medical Termination of Pregnancy Act will not allow for abortion. We're now speaking to Advocate Ameyavikrama, who's appearing for the government in this matter. So, Ameya, one thing we needed to clarify for our viewers: does this verdict mean that no woman can abort after 24 weeks?
Absolutely not. See, we have to be very clear and categorical in understanding the judgment. All that the judgment has said that we have a Medical Termination of Pregnancy Act, which is the statute that governs the right of abortion that has been afforded to every woman in this country. However, like every other right, this right is also prescribed by certain limitations. And there are situations, there are exceptions that have been carved out within the statutory scheme that allow certain women to terminate pregnancy beyond the 24-week limit. So this is in no way an absolute ban on abortion beyond a certain time. However, the court has only reiterated that we have a law which exists, and in the absence of any challenge to that law, we have to apply it as it exists.
Okay. So, but in this case, especially, we saw this lady who is suffering from a mental condition. She has said that she's been suicidal. She's said she's not willing to continue with the pregnancy. So, doesn't this then open up a debate on the right of a woman to choose what happens to her own body?
The right of a woman to choose what happens to her body has already been upheld and been directed by this very court, that every woman has her own right. This case was very peculiar in that the woman has also been examined by medical board time and again, by AIIMS as well, and it was on the basis of this report of AIIMS which did say that it will take into consideration her mental health as well as her physical health through the period of pregnancy, and on the basis of that technical report that the court has taken this view which it has.
Could you tell us what exactly are the observations that the court has made while rejecting this woman's plea? Because one point that has come out that we've been talking about is the issue of the fetus being viable, and the court saying we are not inclined to direct a doctor to stop a child's heartbeat.
As you might have heard during the course of the hearing, that this was really a Hobson's choice, in as much as the fetus, see, at this stage, this is not a question of complete abortion. This was a preterm delivery versus a full-term delivery. Now, were the baby to be delivered today, it would still be a viable fetus. That is, it would have a chance to survive outside the womb, and it would have to be incubated. So this is the question that was before the court, whether it could, after a preterm delivery, direct the doctors to stop the heartbeat of that baby.
Okay. So how does that then tie into this entire question of the choice of a woman? Are we talking about, are we then looking at a situation where when there is, say, a 26-week fetus, this entire question of preterm delivery versus complete abortion, are we then looking at a jurisprudence or a precedent being set with regard to viable fetuses?
What we're seeing is essentially an act of balancing rights of the baby with the rights of the mother. Because at this stage, it's almost a person. But that said, the court has said that we are a pro-choice country. This is not, I would not say that we have to get into the debate of pro-choice versus pro-life at this point. This is really only a reiteration of the act as it exists, of the law which exists. And the court has in fact said that in the absence of any challenge to the statute, we have to apply as it is.
If I may ask you to sort of deliberate on a larger issue as well. Senior Advocate Colin Gonsalves, during the hearing, has pointed out that there is in fact a challenge pending in the Supreme Court on the legality of the MTP Act and the fact that there is a gestational period restriction. What is the status of that case? Can you shed any light on that?
That case is to come up for hearing, but what happens there will have to be seen. We'll see if the challenge stands or the challenge falls.
Thank you very much, Ameya, for speaking to India Today. So clearly there is a question that is being asked by women in the country regarding, can there be a woman who does not want to continue with the pregnancy. But here the court has said that because there is no threat to her life, to her health, and the child, the fetus itself does not have any abnormalities which would lead to any health conditions. Therefore, the exceptions that have been created under the Medical Termination of Pregnancy Act will not apply. The court trying to strike a balance between the rights of the child, the fetus, and the rights of the mother. But this does give rise to a larger debate. If a woman just does not want to remain pregnant, what is the limit of her choice, and can the state and the court, like has been done in this particular case, limit that choice? It is a bigger question of rights of different persons and how they are weighed. But of course, at the moment, the Supreme Court making it very clear that the MTP Act is categorical, that any abortion after 26 weeks can only be done for exceptional circumstances involving the life or the health of the mother or the child. In New Delhi, with cameraman Jagannath, this is Aneesha Mathur for India Today.